Is the new special prosecutor in the scheduled retrial of Karen Read stirring the pot? Stirring the pot is normally understood as intentionally causing trouble or controversy, yet all of you cooks out there watching know if you don't stir the pot, the food will cook unevenly. So, is Hank Brennan, the new special prosecutor, trying to cause trouble or controversy, or is he trying to ensure even application of law? If you want to know more about him, watch this video I did on Hank Brennan. Will reviewing the evidence be inculpatory, meaning the evidence is incriminating, implying Karen Read is guilty? And will that ultimately prove she caused the death of her boyfriend, John O'Keefe, by intentionally hitting him with her SUV, or did she unintentionally hit John O'Keefe and leave the scene of the accident, which resulted in his injuries and dying of her hypothermia in the freezing cold, as alleged by the state of Massachusetts? Or will the evidence be exculpatory, as the defense has been fearlessly arguing she is innocent? Let's watch Hank Brennan in his first appearance before the judge in the motions hearing that took place on the 13th of November, 2024, and see how the defense responds. For those of us who watched the first trial of Karen Read, gavel to gavel, you may remember Mr. Lally, the lead prosecutor, as painfully unenthusiastic, dragging on, and some on Reddit questioned if he didn't really want to be trying the case, or did he even believe in the case? So, as you are watching Hank Brennan, do you think he'll be any different?
To all the attorneys numerous times, I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Ms. Giannetti, do you want to be heard by starting with the whole motion, or what?
I think we can short-circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because, unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense.
If I could be heard briefly.
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them.
Well, you can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task, and if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside a protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the requests of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right, the next motion. So, defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing, so we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard at that time. But I'm prepared now if the court prefers me to.
No, I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. Okay. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there's information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case. And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today. But I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they'd want, but we're entitled to the download. Notably, when the first download was done, the Commonwealth deferred to the defense expert to do the download. That is not my position. I don't defer that responsibility. But it was the defense expert that overlooked the proper reader that was needed for the chips that were tested, and it was the expert that overlooked the fact that there was 3 panels in the system, not 2. And our expert was astute enough to find those oversights, and that's why we now have an independent expert that is going to do this. I know experts differ. They're not frick or frack. They all have different opinions, but we've attached all of the protocol, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it does.
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, 'cause it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, I'll hear you, Mr. Jackson. Okay, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it, Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world of
And
chips.
you have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Burla has now updated software that we believe, I think both sides believe, could be beneficial in culling or teasing out that data set from those chips that didn't exist when Ms. Gaffney did her work previously. She put it on a reader, it was unreadable. It doesn't mean that the data is missing. It means that it's unreadable. As a matter of fact, one of the things that our expert would do and would suggest is that a process called a checksum be done. I'm going to use some made-up numbers, but let's say there's 5,123 bits or bytes on a particular chip. You can do a checksum and determine that there's 500 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert be obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so, inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these chips and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It will provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence, and I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with the motion to continue. I know it's a joint motion, but I need to hear from both sides as to why I should do that. Mr. Brennan?
Can I begin?
Yes. And the request is for an April 1st date. You're not looking to go any further than that, correct?
We are not. We are not. Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these chips in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, or in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates numbers, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial, and it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing
Have you been working on that, though, in anticipation?
We have,
Okay.
yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but have given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I do not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be on our witness list.
All right, so why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay, I have to pause here as I've done a video on the defense's expert on dog bites. The witness, Dr. Marie Russell, who testified, and I shared her education, and the judge accepted that she was an expert. So why is the new special prosecutor saying she does not have the expertise to make what? We didn't get to hear the rest of what he was going to say because the judge cut him off. As you may have remembered, the judge did that a lot in the first trial. However, because this is a retrial, it is treated like a new trial. And the judge must determine that the testimony fits the facts that are in dispute. And there are 5 factors to help determine the validity of scientific evidence. These include 1, whether the technique or theory can or has been tested. 2, whether the theory or technique has been subject to peer review and publication. 3, the known or potential rate of error. 4, the existence and maintenance of standards or controls. And 5, the degree to which the theory or technique has been generally accepted in the scientific community. So this is really interesting because Dr. Russell did not fail the fit requirement. However, I do remember that Dr. Russell did not do a report. So could this be the issue? And if you watch the video I did, you will hear Dr. Russell's opinion. And according to the disclosure requirement, it is rigorous, requiring a signed expert report and a list of prior cases which the expert has testified to, as well as his or her fee requirements. So there may be other reasons why the new special prosecutor wants the witness to be re-qualified to be able to speak in front of the jury. Okay, we only have a couple of minutes left of the motion hearing, and the judge makes a comment that some might find a little shocking when they are trying to schedule the next hearing date. So let's watch and have a listen. Let me know in the chat if you catch it. Then I will let you know my thoughts.
All the hearing on the 9th back in California, so I can't fly that day. So
Well, court ends at what time?
I'm sorry, Your Honor?
You could take, a lot of people take a red eye, right? Can you come out then?
I do every time.
You can't fly out on the 9th, the evening of the
On the
9th?
9th. There's no way I can't make a flight on the 9th.
What about the 16th? It's a Monday. Is that
We're fully booked that Monday and Tuesday.
Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available.
That works.
Jim, we just put Gaston on for that day. Yep, we have a full competency hearing, and we also do on Gaston. About the 12th. Can you just look at that? Did you say the 12th?
The 12th works.
I can do the 12th.
I can do the 12th.
Will accommodate, yes.
All right, so the Daubert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor.
Yes.
So, did you catch it? The judge suggested that Alan Jackson, the defense attorney, should take a red-eye flight. He lives in California and the court is in Massachusetts. Why do I find this shocking? Because a red-eye flight is a late-night flight, normally leaving after 10 p.m. and arriving before 6 a.m. And the term red-eye comes from the tiredness that can be seen in the passenger's eyes. Said differently, bloodshot eyes. Well, are you surprised? Judge Cannoni, in my opinion, lacks decorum, though I must admit judges are pressured to ensure scheduling is done timely, avoiding delays. And over here across the pond, it is just the same. One time I remember a judge telling the barrister on the other side if they couldn't make the next hearing date, their client would have to find alternative representation. I thought that was a bit harsh, given all the parties were agreeable to an alternative date. But we are at the mercy of the court. Well, I'm going to be looking forward to hearing what you thought of the new special prosecutor, Hank Brennan. My first impression was that he appears to be working well with the defense team. And they seem to have worked out a great deal before they appeared before the judge. And this is the way it should be in working practice. You want the parties to work together. Then only go before the court with items, they can agree, so that goes quicker, and then argue issues they cannot agree upon, so that the judge can make a decision on those disputed issues. I found Hank Brennan to be confident, and he is definitely stirring the pot to make sure the legal process is evenly balanced. And you'll remember my, comparison to cooking. When you stir up all the food, you're making sure it cooks evenly. So I think, that's why I've given that analogy, because I think that's what he's doing. And he confirmed he will take accountability if he cannot work within the time restraints that the court decides. So I thought that was really good to hear that. And I think he made a wise decision to hire new experts, recognizing that the state's previous expert, accident reconstructionist, Trooper Paul, was, he wasn't really able to articulate or go head-to-head under cross-examination. So by replacing him, I think that was a wise move. And I like the way Hank Brennan admits where he can his lack of knowledge when it comes to being up to date with his case. And that may be affecting his cadence, that he's just not up to date with everything. As there was a stark difference when he was sure of something, like when he said to the defense that he hired an expert and the defense had no standing to interfere. So he was quite confident when he said that. And he was only inviting the defense out of courtesy. So he's, looking to ensure justice. And he did say that the evidence could change how the case will proceed. So that gave me more confidence that he will be fair when presenting the case. As we know, when Lally presented the case, well, it was just all over the place, wasn't it? Now, there was one little itty-bitty concern I had, which I didn't clip because it was kind of hard to hear, but the special prosecutor, Hank Brennan, asked the court how to do something from an administrative protocol. He asked the judge. Now, I thought this was weird because the judge answered him by saying, "You can ask Mr. Lally." And for those of us who watched the first trial, Mr. Lally was the lead prosecutor, as you'll remember, who appears to be demoted to second chair for this retrial. That gave me pause for thought, and I wondered if there isn't some internal difficulties going on behind the scenes. And maybe, just maybe, Mr. Lally's ego is a bit wounded and he's not offering up his assistance so easily. What do you think? Am I making something out of nothing? Or is everything just hunky-dory behind the scenes? Let me know your thoughts. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.